Good morning, everyone, and welcome to today's seminar on AI risk and liability in the Kingdom of Saudi Arabia. This is Christine Khouri, Senior Counsel with Al Tamimi Digital and Data Team in KSA. It's great to see you all here as we talk about one of the fastest changing areas in law and technology. Artificial intelligence is changing how businesses work, from automating tasks to analyzing data and creating new tools. But as you know, with new opportunities come new challenges, especially around responsibility, rules, and governance. In today's discussion, we will look at how these issues are developing under Saudi laws and regulations, especially considering Sadaya's AI principles and the increasing focus on using AI responsibly and transparently across different industries. We have organized today's session to give you a clear overview of AI-related liability, covering it from different angles. This includes corporate law, digital and data regulations, intellectual property, and dispute resolution. I'm delighted to introduce our distinguished speakers who bring deep experience in advising clients across these areas. We'll start with our corporate partner, Omar Al Humaid, who will start with the corporate perspective, explaining how AI adoption impacts governance, risk sharing, and accountability within companies. And then Associate Ali Abbas from our digital and data team, who will discuss compliance under Saudi data protection laws and Sadaya's AI principles, focusing on how data is managed and transparency requirements. Moving with our IP partner, Ahmad Zaza, who will cover intellectual property and will talk about the challenges of defining ownership and protection for AI-generated content and algorithm in KSA. And last but not least, our senior associate, Ahmad Amanet, will wrap up with the litigation and dispute resolution angle, sharing practical insights on handling liability in cases involving AI errors, negligence, or BAs, and how Saudi courts might deal with such cases. After the presentations, we will have a Q&A and open discussion. So please feel free to share your questions or comments you might have in the chat box, and we will try to cover them during the session or follow up afterward. Once again, thank you for joining us. We look forward to a rich and insightful discussion. And please note that the session will be recorded, and we will be sharing keynotes reflecting on this webinar by next week or the week after. With that, let me hand over to my colleague Omar to begin with the corporate and governance overview.
Well, thank you, Christine, and good morning, everyone. Very happy to be here with you this morning, and thanks for our digital and data team for arranging this event and inviting me to speak this morning. I'm a corporate partner based in Riyadh offices of Al Tamimi. I'll be delighted to take you through some of the legal and governance consideration from an AI in the corporate M&A perspective. Over the next 15 minutes, I'd like to share some thoughts on how the artificial intelligence or AI is shaping the way we handle corporate M&A in particular in Saudi. I'll try also to focus specifically on the legal governance and from a Saudi perspective in particular, looking at both opportunities and challenges that come with the transformation and the use of AI. In this presentation, I'll probably go through a few main areas of main points that I would like to discuss. The first one would be how AI is being used in M&A transactions these days, and what are the key legal and compliance challenges that arise from the use of AI in M&A transactions. The third point I will be looking at, what does that mean for the board of directors who sits on the board of those companies, whether it's acquiring or target company. And then the final is the practical steps that company should consider when they want to use AI, how to be compliant and how to ensure responsibility. Let me begin by basically setting the scene. In Saudi currently, the economy is moving quickly towards digitalization, and the future of digitalization under the Vision 2030 has AI as a central role in this journey. We In Saudi, we have a strong regulatory ecosystem, which is led by SADAYA, or what is known, or the Saudi Data and AI Authority, which is known as SADAYA. And my colleague Ali will give more insight into the regulatory framework, which is also supported by the National Data Management Office. Those are the key, I would say, key governing body for AI. They set the national direction for the responsibility of AI adoption in the Kingdom of Saudi Arabia. At the same time, the new rules like the Personal Data Protection Law, which is, or the BTPL, is changing how companies must handle data, especially when it comes to cross-border transactions. And we will come into that later when it comes to how data must be stored in Saudi, or processed in Saudi, in accordance with the local guidelines issued by the relevant authorities. Uh, so as organizations in Saudi increasingly rely on AI tools to support its deal making, they must also operate within the framework that balance the innovation in one hand with compliance, and in the other hand, the efficiency with governance, and technology with, of course, human oversight, to ensure proper and thorough review is being taken care of. If you can move to the next slide, please. Let's talk about how AI now actually fits into the M&A process. There are I would say, five areas where AI is already making a real difference. Firstly, which we all assume, is that when it comes to legal due diligence, or generally in due diligence, which was traditionally reviewing thousands of documents and pages of contracts, would certainly take weeks, if not months, depending on the complexity of the transactions. With an AI tool these days, it can reduce the time being consumed by the team members that review, or responsible of reviewing the documents. The AI, of course, can help with the scanning and summarizing information in hours, most likely. In shorter transaction, would probably a few days with larger transactions, where it identify the red flags, uh, such as the change of control provisions, or termination of rights, or any undisclosed liabilities from those documents being reviewed throughout the process. The typical second point that we see in how AI supports the transaction is in the structuring and drafting of the transaction. The AI-powered drafting tools can also help with the preparing first version of key documents like SPA, or shareholders agreement, or joint ventures agreement, based on, of course, the standard precedent from prior deals, which help lawyers to reduce the time involved from or avoid lawyers from drafting things from scratch, and help with reviewing and refining to tailor the specific documents to the specific needs of the transaction. I would say the third point, when it comes to regulatory or probably antitrust analysis, AI can help with reviewing and identifying whether a filing of merger control notification is required under a certain threshold, whether in the local jurisdiction or if it's a cross-border jurisdiction, and also can predict the likelihood of the timing of clearances based on the precedent and based on the similar cases that was filed with the relevant regulators here in Saudi and across the cross-border transactions. The fourth point, we'll be looking into the transaction management, where AI-driven platforms can also manage the workflow approvals and the control across multiple teams, keeping, of course, the complex transaction organized on schedule, and help streamline all the review and put altogether the teams in an easy way to communicate, to be more efficient, to have something readily available to be shared when required with the stakeholders. The last point is the post-merger integration, where AI can help compare policies between companies when it comes to compliance manuals and contracts across the merging entities, to help identify any inconsistency or overlapping obligations, something that help management to integrate more smoothly after closing. Uh, so when it's used well, the AI can significantly improve the speed, the accuracy and efficiency, while of course lowering the transaction cost in those kind of deals. But of course, it's important those benefits will come with some legal consideration or legal responsibilities. Um, Let me look now into the challenges. What are the typical challenges that we have, or the risk that we would consider when it comes to the use of AI in M&A transactions? First of all, there is issue when it comes to the data privacy and confidentiality. M&A data room, as you may know, typically will contain very sensitive information, business, whether it's business strategies, employees data, or a client contract, or any business secrets that is going to be uploaded in the data room for the relevant parties to look into. Under the Saudi PDPL law, such data must be processed in Saudi, and it cannot be processed outside, or cannot be stored outside of the Kingdom of Saudi Arabia without the controls approved, without having those controls approved by the relevant regulators here in the kingdom. And if AI platform is hosted abroad, the process of this information could be seen somewhat in breach of localization rules, which or breaches the confidentiality obligations. This is a very important point, and again, that's something probably my colleague will look into in further details. But one of the I would say the main challenges that we see is the storing of data outside of Saudi as a key challenge. The second point I would raise as a risk or challenge when it comes to the use of AI in M&A deals, when it comes to reliability and accuracy. Uh, AI, of course, it's very powerful, but at the same time, it lacks the context, so it may misread anything in bilingual format, whether it's in Arabic or in English, or it could also fail to grasp the specific or the uniqueness of a legal concept under the jurisdiction framework, whether it's a Saudi law or probably a Saudi or a Sharia principle that the AI does not probably grasp as it's supposed to be. And that's why we need a human review to also to remain part of the process to ensure the accuracy and the reliability of the products that is being produced through the AI platforms. The third point we'll be looking at is the accountability and liability. Uh, what happens if AI tools misses a risk, or does not capture a specific issue that should have been caught? The question is, who was responsible? Is it the company, or is it going to be the advisor to be blamed, or even the software provider or the vendor provider? The current regime or the current rules and regulation does not fully provide, I would say, a clear answer to this, which makes the governance and oversight even more critical when it comes to liability and the accountability on the review. The fourth point, when it comes to the professional and ethical duties, lawyers and consultants must, of course, protect the confidentiality of the data that they gather, and must supervise all the outputs of the AI. And that wouldn't happen without the use of proper safeguards that could risk breaching professional standards, or even waiving the legal privileges with of course the relevant stakeholders. Uh, and the final point here when it comes to risk is the regulatory uncertainty. While the key Saudi regulators are moving quickly to establish AI governance rules, it is still evolving. It is still something that to be looked into closely, and that's why companies that adopt AI quickly must therefore stay proactive in anticipating the future legal standards rather than waiting for them to come. I'll move now into the implications for the board and what does that mean. What does that mean? All of this means to the board of directors. The short answer: AI does not change the fiduciary duty of the directors. It changes how the directors fulfill them, but it wouldn't change the fiduciary duty that are stipulated by the company's law. And under the company's law, directors must act with due care and diligence in all informed judgment. And this obligation does not go away because AI is involved, for sure. Um, Let me try to highlight key specific implications here that directors probably need to look into. Uh, I'll look into 5 key points that we see as something that we would probably highlight for the purpose of this presentation this morning. The first one I would look into is the fiduciary oversight. Boards should ensure that management does not rely blindly on any AI generated analysis. They must for sure look into human validation of any critical or legal commercial assessment that the board will take decisions on. The AI governance framework that require the boards to establish formal policies that govern how AI tools are used in transactions, defining who approve them and what data can be shared and how outputs can be verified. The third one is documentation. When AI informs of a decision that should be documented, the board minutes, in the board minutes, this shows that the directors exercise judgment and oversight, not only passive reliance on AI. It should take into consideration, or the board should take into consideration the enough diligence when it comes to overseeing the decision making. The fourth point, when it comes to cybersecurity and confidentiality, where the board members must confirm that any AI vendors must comply with the local Saudi regulation, especially when there are sensitive data stored or processed securely within the kingdom. And 5 is the competency of the board. It is very important that the board should continue to build their digital and data literacy. They don't have to be, of course, to be technologists, but at the same time, they need to have the capability with the limitation to allow them to consider the potential risk in the decision making. Moving into the board governance and the ASG view, which comes beyond the legal compliance, that is also, I would say, broader governance and ASG dimension, which is a big thing now when it comes to, especially those companies are being listed and have obligations to file those ASG returns into the relevant regulators. So investors and regulators and stakeholders increasingly asking how companies are using AIs, not just whether it's compliant, but it's whether it's ethical, transparent, and responsible. The boards of companies should be proactive on their stance by establishing a responsible AI principles that have clear accountability structure, which demonstrate stronger governance and earn greater trust from the market. With the responsible AI use, it's going to become part of the corporate reputation, which reflects on the company's integrity and long-term sustainability. The moving into practical, I would say practical recommendation that we will look into. What does that from a practical steps that can organization take or do right now? We will look into the adaptation of internal policy, one that sets the standards for vendors selection, data handling, and oversights internally, the human validation requirement of all AI-generated output, especially when it comes to due diligence that is being conducted through AI, the contract drafting and validation of analysis. It's very important also to look into the training of the legal and M&A teams to understand both the benefits and the risks of using AI, educating the board through the regular briefings so the board can engage in all informed discussions on AI related discussions. The last point here is the conducting the audit when it comes to all AI assisted processes by checking the accuracy, the bias, and the compliance with the local PDPL regulation, and certainly including consider including or engaging external legal counsel early on to whether AI tool can be used in sensitive or regulated transactions. Together, of course, taking this together, this will help create a culture of responsible innovation, one where technology enhances performance without compromising the governance. I'll conclude here with AI is, of course, is not to replace humans, not to replace directors or the lawyers. It is here to strengthen the judgment and accelerate the insight. In Saudi Arabia, fast evolving business environment, companies that use AI responsibly will, of course, have a real competitive edge amongst their peers. But the success will depend on one thing, which is balance, and balancing speed with scrutiny, automation with accountability, and innovation with integrity. By setting clear governance framework, protecting the data, and ensuring informed board oversight, companies can harness their, of course, AI power safely in line with both the local and global best practices. With this, I'll come to to the end of the corporate part, and I really thank you for your time, and thanks for your listening. Thank you very much.
Thank you, Omar, for clearly explaining how using AI affects company governance, how risks are shared, and who is responsible. In this context, how does AI impact the structuring of M&A or joint venture deals? For example, do you see changes in warranties, indemnities, or purchase price adjustment to reflect AI-related risks?
Certainly, yes, that's AI does actually have a significant impact on the structuring of M&A deals and joint ventures deals, and particularly in relation to liabilities and risk allocation, which puts parties under increasingly pressure to adapt warranties and indemnities that address specific AI risk, which comes with anything to do with the data privacy compliance, the algorithm reliability, and the ownership of IP with the regulators' approvals. There might be, of course, some adjustment when it comes to the share purchase that is being negotiated in such deals, especially in M&As, which include the earn-out based on performance or validation of AI technology. Those changes normally will reflect the evolving nature of liabilities associated with AI systems, and of course, the more tailored contractual protection in transaction involved in AI driven businesses. That's particularly in M&A transaction. What we've seen in joint ventures when it comes to the use of AI, when it comes to IP rights, that's also important to be looked into thoroughly and carefully, which must be replicated and reflected on all the transaction documents to give the right checks and balances for all parties involved in the transaction.
Thank you, Omar. Now
Thank you.
moving with my colleague Ali from the Digital and Data team.
Good morning. Thank you, Christine. Thank you, Omar. My name is Ali Abbas. I'm an associate in our digital and data practice based in Riyadh. As part of our practice, we regularly advise clients on technology contracts for SaaS services, tools, and solutions, and as well as software licensing arrangements. Today, I will be focusing on practical considerations that legal teams and managers should keep in mind when procuring AI products. I will focus on key risks to keep in mind, as well as internal governance mechanisms and compliance functions that should be put in place internally to ensure that AI procurement is a smooth process with key risks identified and mitigated at the outset and proactively rather than reactively. As we're moving towards an AI age, AI systems and tools will increasingly be embedded in the workings of businesses. Therefore, making informed decisions is a crucial step that decision makers must make before procuring AI products. Now, before moving into the practical considerations, it's important to set out the current regulatory regime. AI is a new and rapidly evolving technology, and regulatory frameworks in KSA and globally and beyond are currently light touch. This is to encourage innovation in the space, and also it's difficult to regulate something that is not fully established or fully understandable. So overregulation at this stage can discourage AI companies from innovating, and if they are overly burdened with compliance obligations, it will limit the AI sector as a whole. In KSA, as Omar rightly pointed out, the responsible regulator is the Saudi Data and Artificial Intelligence Authority, SDAIA. SDAIA is not only the AI regulator, but it is also the data protection authority in Saudi Arabia. Now, SDAIA has not issued any standalone AI laws or regulations. Instead, SDAIA has issued an AI ethics framework. This framework is a principles-based regime anchored in fairness, transparency, responsible design, and data privacy protection. Looking ahead, as AI applications mature and sector-specific risks become clear, we can expect clear sector-specific guidelines and regulations in the future. Moving on, another related law, and one that is fundamental when AI products use large personal data sets, is the Personal Data Protection Law. The PDPL is KSA's first standalone data privacy law, and it includes specific compliance obligations for when AI technologies are used to process personal data. Let's take an example of an AI HR tool that screens CVs or candidates to rank them for potential job opportunities. Such a tool definitely helps raise efficiencies and cuts time in the recruitment process, but also such a tool raises privacy and fairness considerations. When using an HR AI tool, it is important to ensure that that consents are obtained from data subjects, especially if the AI tool will make automated decision-making without human intervention. The purpose of the tool should be limited, for example, limited to the hiring process only, and only minimum necessary data should be taken to use the tool to achieve its purpose, and transparency and notices should be provided to data subjects. So candidates must explicitly be informed through a privacy notice if their personal data will solely be processed using AI without human intervention. Another key back-end compliance mechanism is the need to conduct data impact assessments. These must be completed before an AI product that processes personal data is deployed. Now let's speak a little bit more about risks when you're moving from a pilot phase to a production phase. In a pilot phase, AI models operate in controlled, low-impact environments with limited data available. Once deployed and in production, the same system interacts with live data of real users. This drastically increases risk, increasing exposure and potential impacts. For example, in the event of a data breach. This is also a reason why companies should consider using specific or custom-built AI products rather than using large-scale open models such as ChatGPT. The more control a company can have over the AI product that it uses and has internally approved, the greater the risks and exposure can be mitigated through accountability and allocation of liability. And I'm sure many of the attendees today will have used open source AI as part of their daily tasks. This is because tools like ChatGPT are easily accessible and low cost. But what many attendees may not realize is that they open the business up to key risks when they use such tools, especially if they're inputting sensitive data or personal data into these open source environments. In contrast, if a company has an approved AI system that has gone through vigorous internal review processes, including licensing, data governance vetting, and creating a PDPL defensible compliance framework at the back end, as I had mentioned before, things like obtaining consents, providing adequate privacy notices, and conducting data privacy impact assessments. This will greatly limit the risks and exposure that a business is open to. On the operational side of things, open source AI exposes companies to risks such as unverified code with possible backdoor entries, data leakage risks, and no guarantees of patch vulnerabilities. In contrast, if you are using a specific AI product that has been approved by the company, you can, through contractual means, agree on service level agreements that would limit vulnerabilities, provide for testing, and through service level agreements, patch errors that may come up. So another key thing to keep in mind is that when you're using an open source AI, liability is diffuse. There's no single vendor that can be held accountable. But going back to the personal data element or the side of things, as a controller of personal data, the company itself is ultimately liable for breaches of the personal data protection law. So meaning that the company will bear the full risk of any misuse or any breach of open source AI. Again, this ties back to the point that when using AI, you need to use it responsibly and make sure that you have an approved AI product in place that has gone through vetting and has been signed off by the various stakeholders involved. Now, moving on to AI governance controls and mechanisms. AI governance is less about having a rules-based system and more about having ongoing oversight, accountability, and transparency across the lifecycle of an AI product. Core governance principles to keep in mind are accountability. There should be clear ownership of AI systems within the company. For example, technical leads, responsible AI officers, and data protection officers should be involved in the entire process and should sign off where required. Transparency and training is another core governance principle, ensuring that all stakeholders and employees understand how to use AI responsibly is critical, and ensuring that stakeholders are adequately trained on the use of AI is also an important aspect to consider. And finally, another key governance tool is having human oversight. Maintaining human control is key. AI output should always be vetted to ensure accuracy and to ensure it is free from hallucinations before it is used for a decision-making purpose. And finally, security and data integrity should be built in, and embedding a PDPL compliant framework is crucial before you deploy AI tools. We'll also speak a little bit about the PDPL and data localization. So the PDPL allows transfers of personal data in unregulated sectors, subject to meeting transfer requirements. However, there will be certain businesses in KSA that have sector-specific data localization requirements that would require them to host data in the kingdom. For example, financial institutions or government entities would have obligations on themselves to keep their data in the kingdom. So if you are in one of those organizations, it would be important to ensure that you have the appropriate exemptions or approvals in place before you rely on the cross-border transfer mechanisms in the PDPL for transferring data outside the kingdom. And as we all know, many of these new AI products are hosted outside the kingdom. So anytime there is an input of personal data into these systems, there would be a transfer outside of the kingdom. So it's fundamental and crucial to have your transfer compliance regime in place. This includes things like having standard contractual clauses in place, which are approved by SADAIA to ensure that all transfers of personal data are safeguarded. Moving forward, I want to talk more about practical tools that should be put in place internally. Companies should ideally be adopting a formal AI governance framework or policy as an important first step. This policies should clearly define roles and responsibilities, as well as important governance checkpoints throughout an AI product's deployment. Other key practical tools to keep in mind are things like AI registries, maintaining a live register of all AI tools in place with continuing tracking of their purposes and necessary backend compliance being undertaken on a continuing basis. For example, data privacy impact assessments. And when we're talking about AI models that are heavily reliant on personal data, then of course we have the data privacy impact assessments. But when we're using other AI tools, for example, tools that are analyzing financial data or inventory and supplies, in which personal data is not a key element, then separate risk assessments templates should be developed to ensure that the products are being used responsibly. Another practical governance mechanism to consider is having a responsible AI ethics committee in place. This should be made up of key stakeholders from the legal teams, HR teams, and technical leads to review and sign off on new AI products. Unlike traditional software, AI tools learn from the data that is given to them, and oftentimes this includes personal data or regulated data. So when we talk about procurement or due diligence in an AI context, we're not just talking about financial or technical exercise. It's also about ensuring and evaluating ethical considerations, legal and operational risks, and the trustworthiness of the vendors that are being onboarded. And in KSA, regulators would expect companies to verify AI vendors and ensure that their PDPL compliance and their compliance with the AI ethics framework is in place. So in terms of practical considerations, again, having a preliminary AI checklist or questionnaire is a good first step. This should focus on things like, licensing, demos, in pilot phases, service level agreements with agreed upon error tolerances, and if the company is in a regulated space, for example, if they're a government entity or a financial institution, they should ensure that they know where the data is being hosted, and if it's being hosted outside the kingdom, appropriate approvals need to be put in place before the product can be deployed. And if those approvals aren't obtained, then this would be a key red flag and would necessitate, ending the process right there. I think I've broadly covered what I wanted to discuss here, so I think I'll pause and allow Christine to jump in.
Thank you, Ali, for the insightful overview of SADAIA's AI principles and how they guide data management and cross-border data handling in KSA. Building on that, I would like to move the discussion from principles to practical application. Given these regulatory expectations, what practical governance tools or measures can legal and product teams implement to manage AI-related risks in their day-to-day operation and business?
Yeah, just going back to what I said earlier, it's important to have a AI governance policy in place. That policy should dictate who is responsible for deploying an AI product. There should be sign-offs in place to ensure that vigorous testing has been undertaken. And one of the key initiatives that we're seeing across sectors is the implementation of an AI ethics committee, which is usually made up of people like the data protection officer, and now increasingly responsible AI officers, which is a new role that has come up due to the increasing use of AI systems. So ensuring that these responsible people have the oversight of the whole process is important, and additionally, a fundamental practical consideration is training. You as a company, you should be continually training your staff on how to responsibly use AI, and also ensuring that AI environments are clean. And what I mean by that is that you're using approved AI environments rather than allowing employees to use open source software, which would then defeat the purpose of this whole exercise, because essentially, if they are using unapproved AI tools, then the risks that have supposedly been mitigated are not mitigated at all.
Thank you, Ali. Moving now with my colleagues, Ahmed Zaza and Edward Emery from our Intellectual Property Department.
Okay, here we go. Thank you, Christine. Thank you, Omar and Ali, for the insightful information. I wanted to listen more after this session, and I will come to your office, speak in person regarding whatever you said. Okay, here we go. My name is Ahmed Zaza. I am a partner at the Intellectual Property in Saudi Arabia, and I have my colleague Edward. Edward is also with the Intellectual Property Department, and he's specialized in commercial IP and AI transactions when it comes to intellectual property. Today, we are living in a transformative era where AI is redefining how ideas are created, protected, and commercialized. The intersection of AI and intellectual property is not just a legal or technical topic. It is a matter of innovation and opportunity. As AI becomes like powerful, creative, and partner, it challenges traditional notions of ownership, authorship, and innovation, while opening new pathways for smarter IP management and faster innovation. Embracing this intersection empowers businesses, creators, and policymakers to shape future where human creativity and machine intelligence work hand in hand to drive progress and unlock limitless potential. Today, we are talking about a very important topic where we will discuss the outcome of AI and who owns these intangible assets in terms of intellectual property. Let's kick the ball and start this interesting session of the intellectual property and AI intersection. Edward, you may
Thanks,
start
Ahmed.
with the first slide.
Thanks, Ahmed. Yes, and I think it's important to emphasize that this is a developing area of law with the interaction between AI and IP. And so there is significant uncertainty and currently ongoing litigation throughout the world. So as we discuss it, the intersection of the IP rights, we will just give you an insight of what's happening in some of the leading jurisdictions in terms of AI development in IP, and this will be sort of the US, the EU, and the UK jurisdictions, just to give an idea of what is happening around the world and how this will influence AI use with IP in the Middle East region. So yes, here we go.
Thank you so much, Edward. I mean, and trust me, this is not a trick to gain your attention or to receive inbox queries around this topic. This is still developing and legal expertise are needed to advise you on this vague and let's say gray area. So Edward, what we can tell you about the copyright monitoring, trademark screening, etc.
Yes, so I think a good place to start today is to focus on the positive applications of AI and IP. So we've set out here 4 examples of how the IP world is utilizing AI tools, AI systems to help improve efficiencies, to help improve enforcing your IP rights and trying to protect your IP rights in your portfolio, for example. So we've set out here the first one, copyright monitoring. We can use AI technology to help revolutionize the copyright monitoring techniques, and it can detect unauthorized use of copyrighted content across digital platforms. Similarly, for trademark screening, there are now AI tools that are being developed where people can basically put in certain trademarks into the AI tool, and it will be able to assess whether one trademark is similar to another trademark in terms of the likelihood of confusion based on reviewing countless previous judgments around the world. We've got AI tools being used within the patent world, and notably being used to emphasize the sort of the efficiency gains that is allowed. So you can use AI tools to analyze vast amounts of patent databases around the world to identify prior patent or assess sort of assess patentability in relation to getting that protection. And obviously, this is a very important aspect for getting patent protection. And then finally, IP portfolio management. For certain companies, there will be a vast amount of trademarks that they own throughout the world in various different classes. And there are AI tools being used to help optimize filing strategies and sort of maintenance of the registered trademarks, and to help with decisions of sort of key IP portfolio management. So the key message here is that AI can be a tool for IP protection, but as we will come across in the next couple of slides, it can also be a source of IP challenges.
Interesting, interesting. I mean, this means that AI supports trademark screening, patent searches, copyright monitoring, for example, and IP portfolio management by scaling analysis and pattern detection, right?
Exactly, yeah.
Okay. But the main question here, who owns the copyright or the IP rights when like it is generated by an AI tool? So it leads us to the second slide here, the key copyright challenges. I mean, Edward, I can see that you are comparing the US, the European, and the UK regimes. Why did you choose these countries or these jurisdictions?
Yes, so as I mentioned earlier, that these jurisdictions are the sort of the three jurisdictions around the world that are leading the decision or the sort of discussions about how to approach AI within the IP world. And as I've sort of set it out in this slide, there is sort of a differing opinion between the three different jurisdictions. So it varies completely in terms of whether you can use the output or even the training of the copyright tools as a fair use exemption or not, or whether you need licensing or not in relation to it. And each jurisdiction is taking a different approach, which we will discuss later on in this presentation. But yeah, I think what's good to highlight in the first place is to understand what are the challenges that relate to copyright when using AI tools. And there are two major talking points which are being discussed throughout the world, and there is ongoing litigation about this. The first is training the copyright or training the AI tools on using copyrighted materials potentially within sort of available on the public forums. So there is a discussion of whether we need a license or sort of consent from these copyright holders or not to be able to firstly extract these data sets to be able to put into these AI tools, and so that they can train the AI models. And when you use the AI models to produce an output, that they can use the data sets that they've been trained on to be able to create something completely new. And there are arguments that this is using the copyrighted protected works in a way that you need consent from these holders. But then there are arguments on the other side stating that actually, this type of copyright work use should be a fair use, and you don't necessarily need sort of consent from these copyright holders. And this is the discussion that's happening at the moment. On the other hand, the other side of it, where the AI tools create copyright works as an output, there is the discussion of whether who will own the output of this copyrighted work, and B, whether certain copyrighted works will infringe original copyrighted protected works that already exist. And so this is a sort of the discussion that's ongoing at the moment as well.
Edward, I can see like the using of memorization definition and your slides. How can we, like, let's say, mitigate the risk of memorize or re-sample protected works here?
Yeah, I think it's more of sort of a best practice approach on how to use these AI generated tools. The first thing is ensure that your prompting is effective and it's clear and it's creative, and you're not prompting it to basically copy what's already out there. But secondly, in terms of governance that we've discussed before, and best practice use, whatever output that is generated, it's always important to not just take that and use it, but actually do a review and analyze the output to ensure that there hasn't been an inadvertent sort of copying of original copyrighted protected work.
Interesting. Okay, what are the core legal issues? I mean, when machines learn, who owns the knowledge? This leads us to the next slide, maybe.
Sure. Yeah, so this is just a sort of a high level understanding of what issues are out there in terms of this, again, relating to sort of the IP section of copyright. So as I said, training copyrighted works to learn patterns and potential reproduction, that's an issue. Do we need to ensure that we have consent, that we can be able to use it or not without or whether do we need or can we use it, or can the second point, the developers can use these copyrighted protected work without consent, and by claiming that they are using it as a transformative use or fair use. And what I mean by that is you're taking in data sets and you are adapting it and just changing it slightly so that you can use it going forwards. And that for whatever purpose they would like. The third point here, we're talking about the rights holders. This is the other side. Can they claim that there has been unlicensed copying, especially in training the data, and therefore infringement? And we are seeing some litigation cases going on at the moment. The big one being the Getty Images case. And then you've got the issue about different jurisdictions having a different approach in terms of what constitutes as an infringement of copyright works when using AI tools and what doesn't. As we've said from the outset, the law is still evolving on this issue.
Okay, thank you so much. I received a question on the difference between fair use and unfair use. What do you think, Edward, about the fair and unfair use of the content developed by the AI tools?
I think, of course, this is still being discussed globally, and we will, depending on what the outcome of these ongoing current litigation cases that's going in the US and in the UK in particular, that will very much guide us and tell us how we should be approaching the use of the AI tools within the copyright world, and whether we can rely on fair use or not. But as long as there is no certain sort of decision at the moment, as legal consultants, as lawyers, we have to always advise on sort of the most risk appropriate avenue. And what we say is that we would always focus on getting the licensing or the consent from these copyright holders to be able to use these copyrighted data sets on AI tools as a best practice approach.
I fully agree with you. I mean, in absence of like a proper regulation that differentiates between the fair use and unfair use in the AI era, I do believe that we can still apply the general rules of fair use for the copyrighted work or any IP work. When it is commercialized, it is not fair use. When it is used for like proper usage, such like educational, such like awareness sessions, it is a fair use and does not fall under commercialized use. So this is the general rule to like differentiate between a fair use and unfair use. Okay, moving to the next slide, which is like zooming in on jurisdictional differences. Again, we are putting 3 jurisdictions in comparison: Europe, UK, and the US. So can you tell us more about this, Edward?
Sure. So in terms of the approach that Europe are taking, and they are very much leading sort of discussions about AI governance and how to approach it within the IP world. They are focusing more on the sort of the transparency and compliance approach. And what this means is that they want to ensure that there is mandatory transparency on AI tools when they use certain training data. What this means is, they need to highlight what data has been inputted into this AI model, so that it's easy for copyright holders to police whether their copyrighted works has been used or not. Their regulatory approach is quite strict, and they've obviously set out the EU AI Act, which has been slowly being updated throughout 2025. It's an act which, so therefore the enforcement provisions are binding, and there are heavy penalties around it. When we look at the UK, their regulatory approach is relatively light touch. It's still in the sort of the consultation stage. There's an ongoing copyright consultations, getting opinions from different stakeholders within the sort of the copyright world. So that involves creators and copyright holders, as well as the legislative sort of personnel as well, and educational advisors, and they are all contributing to the discussion. So there is no binding IP specific AI laws yet in the UK, but I'm sure this will come into force at some point. And then we've got the US as well. And this, there are various different, it's quite a litigious sort of jurisdiction. There is a lot of litigation going on there, and the debate there is all about fair use, and whether there needs to be a license or whether there doesn't need to be a license. So that's the sort of very much the IP focus in the US. Their approach, currently led by obviously the government and sort of the people that are talking about it, they want to ensure that actually they don't want to focus too much on the regulations, but they want to encourage innovation, and they want to take the sort of innovation first approach, and which has meant that in the US it's quite fragmented in terms of enforceability. I can see we've set out here a couple of cases where we've had differing outcomes, and it's very much a state level sort of approach. Different states are taking different approaches, so it's still sort of really up to debate, and there is definitely still uncertainty in the US.
Edward, I can see like an overlap between all of these 3 jurisdictions. So briefly, do you have like a comparative summary of that?
Yeah, well, I'd say that each jurisdiction is grappling on how to balance AI innovation with IP protection. That is the sort of essential, sort of fundamental talking point. And I would say that the EU is leading the sort of the discussions about enforceability. The UK is more of a sort of taking a cautious approach.
Does it lead us to the second slide, to the next slides now?
Yeah. So
So this
we've
is the
set
one
out
that,
the summary here.
okay, interesting.
And I'd say that the US is prioritizing the sort of the flexibility, and they want to focus more on getting people to develop AI tools and focus on innovation first, and then sort of the regulatory issues coming second. But you know, it's clear that for all three jurisdictions and throughout the world, there is definitely pressure coming from various stakeholders, especially creators and rights holders, as they want to clarify how AI can legally interact with copyrighted content.
I can see the key exception in Europe is TDM. Can you tell us more about TDM, please?
So TDM here is sort of one of the copyright exceptions that you can use without needing to get a consent from a copyright holder, and it essentially is the sort
Which
of
is like text data mining, right?
Exactly, yeah. So it's where you're giving the right for someone to be able to just extract as much data as possible from a publicly available source and use that to train output or do whatever use that they want to be using. And the situation in the EU is that if you don't want your data to be extracted and used, then you have to opt out of the situation. Whereas in the UK, there is a similar exemption, but this is only available for non-commercial use only, which you've mentioned earlier. But it's a very strict limitation. So it's both direct commercial use and not indirect commercial use. So if there can be a link there, then it can go into a grey area, and that's where we're getting sort of litigation at the moment.
I can see that Europe is the leader in terms of AI versus IP. I'm not sure if I'm right, but based on current information, I can see that Europe will take the lead in terms of AI and IP. Do you agree or disagree, Edward? This is a question I received.
Yeah, I mean, I think it's all ongoing, right? All jurisdictions are undertaking their own approaches. You can see that the EU is trying to implement their acts and put in their regulatory sort of regimes in place, and the UK is certainly taking a review of that, and will potentially be guided by the approach that the EU take.
Okay. What about the patent, the inventions? What are challenges we are facing in terms of inventions, patents? I mean, we have to focus more on the this type of IP or this IP right, and I would like to hear more about the outcome, the inventive step, the prior art issues, whatever you have here. I would like to hear more, such like my audience.
Yeah, so I think we just wanted to touch upon sort of the key patent challenges that we're seeing at the moment. And they're essentially in relation to using AI tools to generate invention solutions that could potentially appear obvious to a machine, but not to humans. So there is that sort of gap between sort of the way these AI machines think as opposed to how humans think, meaning that your traditional skilled person test to understand whether there has been an inventive step or sort of a non-obvious step, this may need to be revisited. Which could mean that there's a risk of whether the threshold of it being inventions being available to be patented or not is either lowered or raised too high, and it will affect future applications. The other issue in relation to using AI tools to create inventions and such is that there is the possibility that when it comes to the AI tool generating something, that it's done it, but it hasn't explained, or it cannot explain how it's got to the inventive process step. And this is essentially what we call the black box problem. And therefore, when it comes to filing a patent, you're not disclosing with sufficient details and understanding about how this invention has come about, and therefore invalidating the rights for that patent to be granted. So that's the sort of the inventive and non-obvious issue we've just pointed out here. The second issue is, and although we flagged earlier on that it can be seen as a positive, the AI tool to do sort of a vast review of the prior art scanning, at the same time, the scanning process can bring about a mass amount of technical content as prior art, and it can potentially be overwhelming for patent examiners to be able to assess whether there has been prior use in terms of parts of the claims in a patent or not. But at the same time, also AI tools can sometimes publish or set out unpublished AI outputs, which may mean that it won't fall under the prior use issue. And so there still needs to be improvement within sort of using AI tools for prior art efficiency. And then finally, strategic concerns. AI-generated patents. If you're using these tools, we can easily see that there may be some people flooding the market with lots of different generated patents, which could block competitors and essentially defeat the purpose of having this sort of trademark protection, where it suddenly becomes anti-competitive, and so you will have a lot of patents being granted and blocking out the ability of for people to innovate and create quality work. So this is something that there needs to be a careful eye on as well.
Quality versus quantity. This is something we need to focus on when it comes to patents. Okay, I mean, we spoke about copyrights in the AI era. We spoke about patents. Let's move to the next slide, Edward, the trademark challenges. I mean, when you just feed the AI tool with some ideas, don't you think that they may generate something similar to actual trademarks in the real life? What do you think?
Absolutely, and this is a similar issue when we discussed it about copyright works. So as with output, the best practice is to ensure that you review the outputs, you do your research to ensure there isn't anything out there that already sort of is very similar to what has been created. and to avoid the issue of there being IP infringement. So yeah, that is definitely one of the challenges for trademarks. At the same time, the other challenge is unauthorized use of registered trademarks and logos when you are training your AI tool. Again, this can be constituted as a use of someone's IP rights, and so there's the discussion that you do need a license to use that trademark in order to be able to train your AI tools. So that is something that users will definitely, developers will definitely need to consider.
Interesting. Yeah, I mean, sounds clear so far. But I mean, talking about other IP challenges, who owns the AI-generated IP? What are the enforcement challenges we have? Brand concerns, risk of leaks. Can you tell me more about this, Edward?
Yes, so we thought to set out, other issues, IP issues that is worth considering when dealing with AI tools. So, for example, the interesting example is one that was litigated quite early on within the AI world, is whether a machine can be named as an inventor for AI-generated inventions.
You know, this rings a bell for one incident happened with a monkey in the jungle. I mean, a photographer called Slater, and a monkey came and took his camera and took a selfie for himself or itself. I don't know what to call it. But I mean, Slater as a photographer, he posted this photo on his social media accounts, and PETA, people for ethical treatment of animals, stand up and stated that you cannot use this photo. This is like owned by the monkey. He is the author of this photograph, of this photo. And a debate came into and escalated to the court. After that, I mean, the court decided that the monkey is not a human being, and copyright regulations cannot be implemented on animals. And later on, Slater, the photographer, decided to let's say to split the profit of posting this photograph or photo on his social accounts between him and PETA. So this is like exactly similar to an actual non-AI incident. So can an AI generated inventions be named as inventors? This is the question here.
Exactly. And it has been litigated, and the simple answer is per the current laws that actually no, because it needs to be a living human being. That's what it states in the law. So that was something that was litigated. But then this discussion has developed further. And the questions now we're seeing is who is the author for AI created works? Will it be the AI developer, the user, or no one in relation to using these tools to generate certain outputs, right? And the current discussion is, and it's in relation to, well, it will depend on the prompting that you put in AI tools. The argument is that the IP fundamentals still exist. Yeah. Is the user using the AI tool putting enough creative knowledge, creative ideas into the prompting to make it original? And so therefore the output is sort of just an extension of what the user wanted to create themselves, and it's using it as a tool itself. So that's the dispute that's going on at the moment. Whether it's the copyrighted works, for example, belong to the developer, or does it belong to the users of the AI tool itself? And certainly as well, you have to look at the terms and conditions of these AI tools whenever you're using it, and to see what is stated on these on the terms.
Okay.
Yeah.
That's interesting. I mean, let's move to the, let's say, semi-final slide. What are the risks associated with the AI like generated contents?
Sure, yes. So we thought it would be useful to set out some practical guidance for AI developers. In terms of what are the key risks that they should be sort of having in the back of their mind whenever they are creating AI tools or AI software. Firstly, if you are within the space of using data sets to train AI software, AI tools, then you need to ensure that you verify the copyright status of these data, right? It means that if you do need to use a certain set of data from a source, reach out to them, ensure that best practice at this stage, take a cautious approach, and ensure you get a form of license or consent. There will be other sources of data that is freely available. So if that's the case, that's fine. But ensure that as you are doing this and as you are using data sets to train your AI tools or software, that you are maintaining sort of a license, a record, an audit trail of what data sets you're using and whether it was freely available or whether you managed to get consent, because this will help you in the long term when it comes to potential due diligence, transactions where you've got a purchaser looking into how you are dealing with your AI tool and whether it's not breaching any IP rights or anything like that, and you'll be able to disclose your records with this. The other point to flag, I think, as well, is that there is high litigation risk in certain jurisdictions. It's still sort of an unknown situation. So whenever you are unsure, that please do reach out to lawyers or your legal counsel for their advice, because it's better to be safe than to get involved in some form of litigation infringement, especially when it comes to IP.
We are not promoting ourselves, Edward, right? Okay. I mean, a conclusion for the AI intersection with the IP. What would you like to tell us?
I think the key points to flag is the introduction of AI within society has created a new talking point within the IP world. IP has we've had our laws and regulations set, and we've been using it for decades. But this new technology that's evolving rapidly has obviously brought a numerous amount of questions into the IP world, at least, where we need to now look back at our laws and try and assess from a sort of both legal, regulatory and practical point of view of sort of how best to protect creators and copyright holders, but also innovators of IP and of AI software and developers as well. So that's the sort of the talking point at the moment. The other point to flag is, it's worth knowing that each jurisdiction is taking a different approach. The EU themselves are focusing more on transparency and licensing that's required, so they're taking a more cautious approach in terms of make sure that if AI tools are being using data training sets, then you have to disclose what training sets have been used or not. And then the final point is hopefully in future that we will expect harmonization across the sort of the globe, where we have cross-border convergence, but this will take some time yet. So it's good to keep up to date and with the ongoing regulation changes.
Excellent. Thank you so much, Edward, for your insightful information in terms of AI and IP. We reached to the end of our slides. If you have any questions, we are more than welcome to receive any.
Thank you, Ahmed and Edward, for the detailed overview of the challenges around ownership and protection of AI-generated content and algorithm in KSA, and for the interesting examples you shared with us. On that note, I would like to look at the commercial side, especially when companies work together on developing AI solutions. When AI solutions are co-developed with vendors or partners, how should companies approach joint ownership, licensing, and a future commercialization right?
Thank you so much, Christine, for this question. I mean, when AI solutions are co-developed with vendors or partners, companies should clearly define ownership and intellectual property rights in a written agreement, such like any other contractual agreement between two parties. The contract should specify who owns the underlying technology, the newly developed models, and resulting data. Joint ownership is the core area here. The clauses must outline each party's right to use, modify, or commercialize the AI independently or jointly. This is the most important point that must be taken into consideration. Licensing terms should address exclusively duration, royalties, and territory. It is very important to protect confidential information and trade secrets. And finally, I can conclude that all of any agreement, it should include dispute resolution and exit provisions like any other agreements. So this is in general what I can advise my clients and audience on.
Thank you, Ahmad, and thank you, Edward, once again. Moving with our last session, the last part of our session today with you, Ahmad.
Yes, thank you, Christine. For the last 15 minutes, we'll be focusing on what can go wrong in practice and how to prevent disputes or prepare for them when they do arise. Our goal is going to be to give you a simple and practical playbook that you can apply. Whether you're procuring AI from vendors, or you're deploying AI internally, or using or embedding it in your services or products for your clients. In terms of the questions that we're hearing from our clients right now, it's what is our exposure and how do we control it? And we'll answer those questions by anchoring them on 3 pillars. First, clear contracts that allocate risk. Second, everyday controls that create evidence in the event of a dispute. And thirdly, having a plan for when issues do arise. It's always helpful to have real life case examples. So to kick things off, we're going to look at a public case that was reported widely in the international media in the last couple of weeks. And that's the case of a Deloitte AI-assisted report. So Deloitte was commissioned in Australia by the Department of Employment to carry out a review of the department's compliance framework and IT systems used in automating penalties in the welfare system in that jurisdiction. The report produced by Deloitte was found to have widespread issues after the report that was produced by Deloitte found widespread issues in the IT systems used in this automation. However, after delivering this report to the client, it was found to contain multiple errors, including non-existent references and citations. So basically, this report contained hallucinations where AI models filled in the gaps, misinterpreted data, and tried to guess answers. Deloitte conducted a review after that, after these issues were pointed out, and they corrected the report, substituting the references, but wound up maintaining the substance of the report and its findings. In the second version of the report, they wound up adding a reference to the use of generative AI in the appendix. So the use of AI in this review and study that Deloitte carried out wasn't disclosed to the client initially. To resolve this dispute, Deloitte agreed with its client, the federal government in Australia, to provide a refund of $450,000. So what are the key lessons that you could take away from this case? First, AI use should be disclosed in contracts with clients and customers or engagement letters when it comes to professional services. Also, it should be disclosed whether or not AI generated materials will be human reviewed and the level of that review. In terms of written work delivered to clients, you should maintain a simple evidence file, the sources, reviewer sign-offs, etc., that can be turned to in the case of a dispute. Also, you should have, when you're procuring AI-assisted services, you should have a clear acceptance criteria whereby unverified citations should be deemed non-conforming and a breach. So with that, let's turn to broadly where AI deals can go wrong. First, we have misscoped promises. Basically, buyers think they're purchasing a solution that's going to work on their data and in their environment, while at the same time, vendors think they're selling access to a tool with results that are as is. So that expectation gap then becomes a dispute where accuracy or integration falls short. Second, we have invisible dependencies. So AI performance depends on data quality, also access to systems, compute constraints, and safe operating settings. If your team can't deliver clean data or the vendor throttles model usage, then the KPIs can slip and both sides wind up pointing fingers at the other. Third, we have accountability fog. So this is when outputs are wrong, infringe rights, or cause harm to clients or the public. Who's going to bear the responsibility for that? If the governance and the logs are thin, it's going to be hard to prove whether the issue came from the training, the data, prompts, fine-tuning, integration, or misuse of the AI. These problems can be avoided if you first align expectations in the contract. Second, embed Saudi legal and regulatory requirements into the deal. And thirdly, operate the system under an internal policy that creates a defensible record that you can turn to, whether you need to bring a case against the counterparty or whether you need to defend a case before the courts or arbitral tribunal. So with that in mind, let's turn now to the applicable Saudi law and evidence rule. evidence rules. So in terms of the civil transactions law, the law provides clear remedies for breach. The non-breaching party can demand performance or termination after notice and seek damages. Minor breaches may not justify termination. In terms of impossibility force majeure, if performance truly becomes impossible beyond the party's control, then the obligation and the counter obligation may fall away. The court can award partial or temporary impossibility has tailored outcomes by the court. Third, in terms of damages, the court is going to aim to put the victim back where they would have been had were the breach not to have occurred. Under the law, actual losses can be recovered as well as provable, foreseeable lost profit. And in terms of calculating damages, the court is going to look at causation and also mitigation, rather mitigation steps took place to mitigate the damage or not. In terms of vicarious and operational liability, so employers are liable for employees' wrongful acts in the course of their work. So, i.e., in the scope of the employment, which could include misuse of AI. Operators of things requiring special care bear liability unless they prove causes beyond their control. So if a thing by its nature or under another statute must be handled with special precaution to prevent harm, the person in charge of it is liable for damage that it causes unless they prove a cause beyond their control. In an AI context, while things are traditionally physical, the CTL's test is functional. So if an AI-enabled systems operation presents heightened risk, for example, clinical triage, credit adjudication at scale, safety controls, or content systems that could trigger regulatory breaches, then the court could view it as requiring special care, particularly where sectoral rules such as SEDAI's ethics, guidance, the personal data protection law, for example, mandate controls. In terms of the law of evidence, we're going to look at a few key points for potential disputes relating to AI. So parties under the evidence law can agree to evidence rules. So if you put evidence protocols in the contract, for example, what logs to keep, how to exchange them, then courts will generally honor them if they're in writing and not against public policy. This would be the legal basis for a contractual evidence protocol, which would require vendors to preserve and produce incident-related data, as the vendor is likely to have, in the case of a dispute with a vendor relating to AI use, the vendor is likely going to have much of the evidence that you would need to rely upon. So having an evidence protocol in place in the contract is key in terms of anticipating potential disputes. In terms of the burden of proof, under Saudi law, the claimant has the burden of proving its case, and the defendant rebuts. So when contracting for AI, you need to make sure that your side can actually prove the facts that you'll rely on in the case of a dispute. So, for example, KPI failures, version histories, notices, etc. Under the law of evidence, digital evidence does have equal weight. So data generated, stored, or transmitted digitally, including logs, emails, system exports, or signatures, do count like writing if it's retrievable and comprehensible. Digital originals and certified copies can have full probative value before the courts. And reliable extracts can stand if they're identical to the original source. If a party refuses to provide proof needed to verify digital evidence without a good reason, then the courts may treat that as evidence against them or deem their right to rely on it forfeited. Courts can order the other side or third parties to produce relevant documents, and unjustified refusals can be treated as presumptive proof against that party. In very technical cases, and we can anticipate that cases related to the procurement of AI systems and the use of AI would fall under that bucket. Courts are likely to appoint technical experts. So it's key that you build your record, your internal record, so that in the event of a dispute, an expert can trace what happened clearly. Now, in terms of what you can contract for in terms of warranties, indemnities, and liability, contracts are performed in good faith under Saudi law, and clear written warranties are enforceable. For sales and services, Saudi law recognizes defect and title warranties by default, and parties can tailor them in the contract. In terms of good practice, it's a good practice to state that the services will match its description and agree to performance measures, that the vendor has the rights to models, data, and tools it supplies. No hidden third-party data or licenses are required. Security and uptime meet stated levels, and updates to the system will not materially degrade performance, as well as to agree to IP non-infringements. In terms of warranties, courts can strike down harsh boilerplate in standard form terms, and if a clause is unclear, it is read against the drafter. Also, fraud or willful concealment voids disclaimers. In terms of indemnities and their enforceability, so indemnity clauses generally are upheld if they're written clearly. They work alongside damages rules, and parties can allocate who pays for IP claims, data security violations within their control, and regulatory penalties attributable to their breach. However, you cannot contract out of liability for your own fraud or gross error, and vicarious liability still applies. So employers are responsible for employees acting in scope. Agreements that try to block a party from basic legal rights or are grossly unfair and boilerplate may be reduced by the court. So in terms of, with this in mind, so in terms of drafting tips, you should tie indemnity to control, such as design and training under vendor control versus your data / instructions. And you should require cooperation and control of defense, carve out settlements that admit fault without consent. In terms of caps on liability and exclusions and how courts will treat them, caps and exclusions are generally respected if they're clear, reasonable, and negotiated, except you cannot cap liability for fraud or gross error. Parties may also agree who bears force majeure risk. In terms of liquidated damages, preset sums are allowed, but courts may reduce them if excessive or increase them if actual damage is higher due to fraud or gross error. If no liquidated sum, courts will award actual loss and foreseeable lost profit. In terms of standard form terms, in click-through or take it or leave it terms, harsh limits can be amended by the court or set aside for fairness. So unclear wording in those terms would be interpreted against the drafter. So in terms of a practical structure for AI deals, layered caps for ordinary breaches capped at a multiple of fees, super caps or uncapped for IP infringement and vendor-caused data security incidents. You can also exclude indirect consequential losses except for carved-out categories, and preserve specific performance where a fix is feasible. In terms of change control, audit, and transparency, you should agree to a simple change process with notice and your right to test and refuse risk-increasing changes. You should also, in your contracts, include audit rights to see security controls, development practices, third-party components, and key model or system documentation. For AI-assisted deliverables, that you will be accepting from the vendor, you should require disclosure of the tools and a retained evidence file of sources and reviewer sign-offs. In terms of engagement letters for professional services, there are a few key points. You should disclose use or potential use of AI in the engagement. Also state whether AI-generated materials will be human reviewed or verified before delivery. You should also label deliverables to reflect the level of human review carried out in the course of preparing the deliverable, and also make unverifiable citations or sources non-conformance. So now that we covered what to keep in mind at the contracting stage, let's look at how you should operate on a day-to-day basis in terms of being dispute ready. And some of these points my colleagues have already covered, but we'll go over them again. First, you should adopt an AI policy that's aligned with SEDAIA's principles. That policy should define permitted uses, what's allowed, what's not allowed, and when human review is required and what level of human review will be carried out. Also, during the course of your operations, you should build evidence by design. So you should set up logging that will give you the evidence that would satisfy a court or an arbitral tribunal if you need to go to litigation. You should have a saved readable trail of key settings, versions, inputs, and outputs for important work, because at the end of the day, you're not going to be able to win a dispute before a court or arbitral tribunal if you don't have evidence available. Also, in your regular operations, you should have ongoing checks, monitor performance and fairness, log any incidents and fixes that were carried out, such as bias complaints and hallucinations. These steps are going to not only reduce the harm, but give you the paperwork that you're going to need, and that will be expected by a court or an arbitral tribunal. So to conclude, in terms of the playbook that you should have in place for when disputes arise, to sum everything up, you should have a policy for preserving the evidence that you will need, such as hold emails and system records, saving the version that was in use when the incident occurred. For documents, you should have a file, have an evidence file that contains the citations and sources the human review that was carried out to verify the findings in that document, etc. Also, you will need to carry out an internal investigation. What changed? What were the inputs? Was the internal policy followed? When carrying out this AI function or providing the service with AI. And you should also map the breach or the incident to the contract. So which promises failed, what notices were given to the client, and were the cure periods followed. And in terms of communicating the breach, as we saw with Deloitte, these incidents can become public. It can become public. So it's a key to have a communications plan in place. So that would be developed with your internal counsel and external counsel. So you need to have one voice to your clients, regulators, as well as the public. And in terms of escalating any breach, prior to going to court, you need to have send notice, agree to any quick fixes, before deciding upon court or arbitration if needed. So that about sums everything up for my presentation. I'll leave it to Christine for any questions.
Thank you, Ahmed, for sharing practical insights on dealing with liability in cases involving AI errors and how such cases might be addressed by Saudi courts. Based on your experience in the market, are there any notable GCC or KSA cases or any regulatory enforcement actions related to AI that in-house counsel should be aware of?
At this time, we're not aware of any public final judgments that squarely turn on AI, either in Saudi or the broader GCC. But do keep an eye on our law update publication that's published monthly. We will discuss any judgments made available in that publication. However, with that in mind, and as we already discussed, the litigation rails that will govern AI disputes are already in place in KSA. So in-house legal teams should watch for three buckets. First, general liability under the Civil Transactions Law. Second, regulatory enforcement, as my colleagues already discussed, under the Personal Data Protection Law, cybersecurity, and e-transactions regime. And third, SEDAI's National AI Ethics and Adoption Guidance that regulators and the courts will likely look to when they're assessing diligence.
Thank you. Thank you, Ahmed, and all our speakers and participants for this engaging discussion. We hope this session has offered valuable insights into the opportunities, challenges, and responsibilities associated with AI. As our scheduled time for this session has now concluded, we are happy to address any additional questions separately. As mentioned at the beginning of the session today, we will also be sharing key takeaways from the seminar by next week or the following week, and looking forward to seeing you all at our upcoming events. Thank you all for attending.